Are you pleading guilty to the offenses you have indicated because you are in fact guilty of these charges?
Yes.
Young Thug has pleaded guilty in his years-long racketeering trial out of Georgia. We're going to break it down for you right now on this emergency sidebar. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. All right, everybody. So this is an emergency sidebar episode. As you can see, I'm not in the studio, but that is because we have quite the development right now in one of the most wild trials that we have ever seen. And after 2 years, rapper Young Thug, real name Jeffrey Lamar Williams, has pled guilty in his RICO trial out of Atlanta, Georgia. If you recall, prosecutors originally charged over 24 individuals here, alleging that Williams was operating and directing a criminal organization that engaged in murder, drug dealing, armed robbery, assault, weapons possession, that YSL was not really a record label, as defense attorneys and defendants claim, but it was really a gang terrorizing the Atlanta community. And this has been a crazy trial, if you have been following it. Almost a year of jury selection. The former judge, Earl Glanville, was recused. An attorney was held in contempt of court for not disclosing how he found out about a private meeting between the judge, prosecutors, and a key witness. That's actually what got Judge Glanville in trouble. And that contempt was actually reversed by the Georgia Supreme Court. There was heated back and forths between defense counsel, prosecutors, the judge. There was smuggling of contraband in the courtroom. A defendant was stabbed in jail. There was arrests of attorneys in this case. And just recently, there was a fear that there would be a mistrial. Because what happened? Prosecutors, they called this rapper to the stand, known as Slime Life Shawty, real name Wunny Lee. And as he's testifying, he was reviewing an Instagram post in front of the jury, but the state made a mistake. The state improperly put up an unredacted version of that post. They asked him to read it, and he inadvertently reads the hashtag Free Quay.
Hashtag 2Bs, life size.
Okay. And is there another hashtag?
Free Quay.
The jury should not have heard that. Okay, the jury heard that two of the defendants have a nickname of Quay. So jurors, they're not supposed to know that these individuals are locked up in jail. And by the way, this witness had also made a prior reference earlier how one of the defendants was locked up. That is very, very prejudicial and harmful to the defendant's case. So the new judge assigned to this trial, Paige Whitaker, had entertained a defense motion for a mistrial. But there was no mistrial because you know what happened? People started taking plea deals. So 3 of Williams' co-defendants, they pled guilty. Quamarvius Nichols, Marquavius Huey, and Redalius Ryan. All 3 of them agreed to plead guilty to racketeering conspiracy. And again, that's, this is a legal agreement to violate the racketeering laws, and a legal agreement to further a criminal enterprise. So you need an agreement, and you need all of these overt acts or overt steps that are taken in furtherance of this. Now, for his one charge of racketeering conspiracy, Nichols our understanding, was sentenced to 20 years in Georgia State Prison. He'll serve 7 years behind bars and then spend the next 13 on probation. He had credit for time served for about 29 months, so nearly 2.5 years. Huey entered a guilty plea to racketeering conspiracy, plus other reduced charges of robbery and firearms possession. He was sentenced to 25 years, 9 years in custody, 11 years on probation. The last 5 years were suspended. And Ryan had also entered that guilty plea, and he was given 10 years in prison, but he had his sentence commuted to time served. The problem for Ryan is he's already going to be behind bars. He's going to stay behind bars because he's already serving life in prison for the 2019 murder of another teen when they were both just 15 years old. He is the youngest of the original defendants that were charged in this enormous RICO case, 20 years old. And now Williams has pled guilty. And he pled guilty to participation in criminal street gang activity, 3 counts of violation of the Georgia Controlled Substances Act, possession of a firearm during the commission of a felony, and possession of a machine gun. He pleaded no contest to conspiracy to violate the RICO Act and participation in criminal street gang activity under the leadership charge, meaning when we say he's pleading no contest to these charges, or these 2 charges, meaning he's pleading guilty, but he's not admitting his guilt. And that's an interesting distinguishing part right there. But this was a non-negotiated plea, meaning the negotiations broke down between the defense and the prosecutors about what the punishment should be. And so now it's up to the judge, up to Judge Whitaker. And before we get into what the judge decided, both sides tried to lay out the parameters of what exactly Williams is admitting to and what he's not admitting to. And both sides recommended what his punishment should be. But Williams himself had something to say as well.
I take full responsibility for, my crimes or my charges. I want to say sorry to my family, my mom. My mom got 11 kids. I can't say all their names, my managers, my kids that's not here. Really everybody that got something to do with this situation, I want to say sorry for just having so much time invested into this, and I am a smart guy, I am a good guy, and I really got a good heart, I find myself in a lot of stuff because I was just nice or cool, and I understand that you can't be that way when you reach a certain height because it could end bad. Out of this type of situation, I promise you I won't ever be in this type of situation again. I'm going away. I've learned from my mistakes. I come from nothing and I've made something and I didn't take full advantage of it. I'm sorry.
So some words there from Mr. Williams. We rarely get a chance to hear him speak. And now, what did Judge Whitaker decide?
I appreciate that you do realize how much of an impact you have on people. It's past your neighborhood. It's worldwide, especially young people. And having come up from where you came up from and living in and around that, that gangs are damaging to our community. And it may be that a whole lot of rap music and the rap industry is, honestly, it sounds like a modern day version of kind of WWE wrestling that used to be on television where people would just get up and posture and act like they hated each other. And it may be that that's a lot of what is going on in the music industry with rap. But whether it is fake or not, it has tremendous impact on kids and young people who think, this is cool, this is what I want to do. Look at him, he's a millionaire. I can do that by being, a gangster in the streets. And that's not true. What you're likely to have happen to you if you're a gangster in the streets is you get shot, you get killed, or you get thrown in prison. And those are, by far the most likely outcomes. And, you've been in here watching the trial, and you've seen the pictures of Mr. Ryan posing with a gun as big as he is at 15 years old and going out and shooting and killing another teenager. And that's what gangs do, and that's unfortunately a lot of what rap music does. And if you are a modern day John Lennon, he might have rapped too in this day and age. I don't know, but I know you're talented, and even if you choose to continue to rap, you need to try to use your influence to let kids know that that is not the way to go, and that there are ways out of poverty besides hooking up with the powerful guy at the end of the street selling drugs. And, I know that happens for protection sometimes, but a much better way would be getting an education and hanging around with people who set a good example. And you be one of those people that sets a good example. All right, so that's my high horse on that. I could also go on. But I want you to try to be more of the solution and less of the problem. All right. All right. So it is not lost on the court that the state, had they been able to come to agreement on certain special conditions, was willing to entirely dismiss the RICO count, was willing to entirely dismiss one of the gang counts, and was willing to entirely dismiss this, machine gun count. Was willing to give a sentence that permitted Mr. Williams to walk out of the door today, and therefore does not seem to be particularly worried that Mr. Williams, if on the streets, would be a danger to society. I'm taking that into consideration in crafting my sentence. And in permitting a NOLO plea to the RICO count and one of the two gang counts, I would not be permitting the NOLO to the one if you were not pleading guilty to at least one of them. But you are, and y'all admit a factual basis for the counts that you are pleading guilty to. I find there to be a factual basis for those counts, and for the remaining counts with which you are charged. I am going to impose a sentence, and I've taken a little bit of the suggested special conditions from the defense and a little bit of the special conditions suggested by the prosecution.
So she decided the total sentence would be 40 years in prison to serve 5 years, but that is commuted to time served. And he has 15 years probation. But if he violates the terms of that probation, if he gets in trouble, he could be looking at 20 years in prison. That 20 years in prison is backloaded. So he has to make sure that he does not get in trouble. And by all accounts, it appears that he is going home. Since this sentence was commuted to time served, it looks like he's going home. But let's talk about it right now. I want to bring in right now a very special guest. He is coming to us right after court. He was just in that courtroom. I'm joined by criminal defense attorney Doug Weinstein, who is DeMonte Kendrick's lawyer in this case. Doug, so good to see you. Thank you so much for coming on. What is your take on this? Because young Thug, after all is said and done, after 2 years, after everything I just described, he's going home.
He is. And great to see you, Jesse. Thank you for having me on. Yeah, this has been a stressful week, obviously, for everybody. A lot of negotiations going on back and forth with all the parties. And I'm really glad that although they didn't reach a deal, but I'm really glad to see Jeffrey going home. It's where he should be. He shouldn't be locked up in the jail in Cobb County. And so he took a big roll of the dice today, and it paid off for him. That guy, he has some nerve. He's very brave.
What do you think led to this?
They got, they got so close in the negotiations, as you heard by watching that. And it was really the special conditions, these onerous special conditions that the state wanted to put onto Jeffrey. I think that, I'm just guessing here, that was the issue. So rather than accept that and go home and go home confidently, like, no, okay, if I take this deal from the state, I'm walking out the door today. Jeffrey made the very difficult decision to do a non-negotiated plea and let the judge decide what his sentence should be.
And in terms of just going into plea deals, I mentioned before how several of his co-defendants pled guilty as well. Was this just bound to happen? Because after the whole mistrial debacle that was, a week or 2 weeks ago, was that what basically fueled the idea, hey, let's start trying to end this case?
I can't speak for Jeffrey or his counsel.
Sure.
Speaking on our behalf and on behalf of what I guess motivated everybody, is it was very clear that after last week, after the motion for mistrial, that the judge was encouraging the parties to try to come together to see if we could reach plea agreements. And she doesn't have a lot of power in that sense, but she can push maybe a little bit. And given that, we got together and we talked. And I wouldn't say it was inevitable. It was not inevitable that Jeffrey Williams was going to enter a guilty plea that would permit him to go home. And you can see that it wasn't inevitable because right now in the courtroom, you've got my client, Mr. Kendrick, as well as Mr. Stillwell, who are proceeding to trial. I mean, proceeding to a jury verdict.
By the way, how does that work? Walk me through that. Your clients are still on trial. This jury still hears this. Do they, I mean, what do they ask what happened to the rest of the co-defendants? How does this work?
Well, I'm sure in their head they're going to ask what happened to the co-defendants. I'm going to have to get together with Max Shart, and we are going to come up with a proposed jury instruction. I imagine that the state will also come up with a proposed instruction, and the judge will make a decision as to how to instruct the jury. And I think it's going to be something to the effect, some version of, obviously, as you can see, some defendants are no longer present in the courtroom. You are not to take anything from that. You are not to speculate or guess why they aren't here. You have to remember there's a presumption of innocence for those two defendants that remain, and we carry on.
That would look like, that would look like a weakness for the prosecutors. If you're sitting on the jury and you see that there's no defendants there, it makes me wonder if the jury is looking at perhaps a weakness in the prosecution's case.
There's lots of theories as to whether that is helpful to the two of us that remain or if it's harmful.
Was there a deal offered for your client? Was it rejected, and why was it rejected?
There was a deal offered for my client. My client, and by the way, my client is the only one that can accept or reject those deals. We do not make those decisions. The public doesn't make the decisions. The mom doesn't make the decisions. Only the client makes that decision. And he rejected that deal. And the main reason that he rejected that deal is they wanted him to plead guilty to things that he didn't do. And one in particular, they were insistent that he take responsibility for the death of Donovan Thomas, which he had absolutely nothing to do with. And while the years might arguably look good, he is absolutely not willing to take responsibility for Mr. Thomas's death when he had nothing to do with it. And that's what killed any hope of a deal.
Do you think that there could be room for negotiation for that to be dropped and your client be able to take a deal that's acceptable?
Throughout this process, even though we do think we're winning, we have to be open to the possibility of plea deals. It would be irresponsible and in violation, I guess, of my ethical obligations to just reject them out of hand. So if they want to come back to us with some type of an offer that removes a requirement that we take responsibility for a death that we are not responsible for, then we will certainly entertain that, and I'll give it to my client as I'm obligated to do.
Why do you think Judge Whitaker, because again, if we're talking about Jeffrey Lamar Williams, who prosecutors said was the head of this criminal organization, why do you think, what were some of the factors you think led her to say he can go home today, that the sentence could be commuted, that there's no prison time? I think she mentioned something about what the prosecutors had offered, and what the prosecutors had offered kind of gave her a sense of maybe he's not as dangerous as they're suggesting. What do you think the factors were that led Judge Whitaker to impose this kind of sentence?
I think that is a major factor. The fact that the prosecutors had to put on the record, because requested by the judge, to know what that offer was. And the fact that the prosecutors, it's exactly what you're saying. The fact that the prosecutors had offered probation demonstrates that the prosecution did not believe Jeffrey Williams was a threat to be out on the streets. So I think that gave the judge tremendous latitude to craft a sentence that would, again, allow him to return home today.
And the idea that, he also, there was other restrictions put in place too about where he can go, what he can do, what he can't do. What did you make of that?
Most of the restrictions that the judge put on Mr. Williams were those that were recommended by his own attorneys. So obviously those were ones that he was comfortable taking. I'm not going to speak for Mr. Williams, but I'm sure that he hated to plead guilty in this case, and that this was done for pragmatic reasons. Just as Brian Steele put on the record today, he wanted to get home. He wanted to see his family. He has obligations to them. He had medical issues he needed to take care of. And while I guess Brian said 3 more months. Who knows how much longer this trial is going to go on? So, Jeffrey is an intelligent man. I think he just weighed things and viewed this as being in his best interest.
Yeah. So some of the conditions were he has to stay away from the Atlanta metro area for the first 10 years of
Yeah.
probation. He's permitted to go there for weddings, funerals, graduations of immediate family members, medical emergencies,
Right.
no contact with the defendants in the case, can't have
Yeah.
a firearm, things of that nature.
Yeah.
The idea that this is concluded for a number of these defendants, I don't know if you've had an opportunity to speak with Brian Steele, especially because he became a central figure in this case as well. What is that feeling like to not be a part of a case that has consumed your life for such a long period of time? I don't know if you had a chance to speak to him about it. It feels like maybe like a sense of relief, I imagine.
I don't know. I haven't gotten, obviously I congratulated him when this was all over and
Yeah.
thanked him for, all the amazing efforts and lawyering he did to not only help his client, but to help all of us. But I didn't get a chance yet to talk to him about how he feels now that this is complete. I know that Brian, and he's put this on the record so I can say it. I mean, he wanted to fight this all the way to a jury verdict. He is winning. We are winning this case, and there's always a degree of disappointment when you can't go all the way, especially when you think you're going to get the verdict in your favor.
But pleading no contest to 2 of those charges, essentially, as I mentioned before, you're pleading guilty, but you're not admitting guilt. Is that a win in and of itself?
Well, look at what the charges that were leveled against Mr. Williams, and he walked out of the courtroom today and is going home. That's a tremendous victory. The state can say whatever they want about the victory, about the fact that he pleaded guilty, but the reality is Jeffrey Williams is going home. And I can't view that as anything but a victory.
There was one thing I was confused about. So a large portion of today's hearing was both the prosecution and Brian Steele, I guess, disagreeing about what exactly he's admitting to or what exactly he's pleading guilty to or what the statement of the facts were. Can you walk us through exactly what that disagreement was?
Sure. I mean, it's a fundamental disagreement about pretty much everything. I think what Brian was agreeing to is, yes, there are the elements necessary, and there was a factual basis for Mr. Williams to to plead guilty to those counts that he did plead guilty on, but he took exception with pretty much everything the state had to say, and this is. It's not surprising. In a non-negotiated plea, the state is allowed to stand up and proffer their version of events, just as the defense is allowed to stand up and proffer our version of events. And that's what you saw occur today. So the parties very much disagree about what happened, who was responsible for what happened. And it was a chance for both of them to get that on the record in front of the judge. So when the judge was entering her sentencing recommendations, she had those proffers. She had that basis from which to make a reasoned decision.
Now that Judge Whitaker's been overseeing this case for a little bit now, what's your impression of how she's been doing, jumping in and handling this?
Fantastic. I think Judge Whitaker is doing an amazing job. I think, as maybe what Keith said, that she has brought order to a process that was fairly disorderly. She brought fairness to a process that has been, I would say, constitutionally unfair prior to her taking over. So while she catches some criticism on social media, I think it's unfounded. I'm not just saying this because I remain in the case. When this case is over, I expect to be saying the same thing about Judge Whitaker.
That's great. And let me ask you this. That whole idea about the mistrial, is that over because the 2 defendants that specific episode involved, they have pled guilty? Is that not an issue on the table? Is this case progressing forward? As you said, you mentioned you're going to do a jury instruction to explain where everybody is, but is this case going to be progressing forward?
We operate under something called the Harvey rule in this case, which is an objection or a motion made by one defendant is automatically joined by all defendants unless we specifically opt out. So as far as I'm concerned, that motion is still in play. I am going to raise it again on Monday morning. I am going to ask for a mistrial with prejudice. So the state can be aware of that when they tune into your show. and see this, but I will be raising it. I think it's still on the table, and I'm not going to let that issue go.
How did that happen? How did the prosecutors allow an unredacted version of that Instagram post to be read in open court?
How has it all happened? How how have we had 50 or so mistrial motions in this case, starting on the very first day? The very first day, the state put up a slide in their presentation to the jury that had information on it that the judge had ruled was not allowed to be displayed to the jury.
Forgot
It
about
is
that.
not,
Yeah.
it is not, don't forget, yeah, it is not a new thing. This is a systematic failure on the part of the state to do their damn job over and over again. They don't prepare witnesses. They're sloppy. They have mistakes. They elicit testimony from witnesses that they know should not come out. And that is why I say, when you look at the totality of the circumstances over the last year, we should get a mistrial with prejudice.
Doug, thank you so much for coming on. I don't want to take too much of your time. I know you need to get home. It's been a long day, but really, really appreciate it. Thank you. We'll continue to follow it. And again, just what a development in a case that has a lot of developments. But thank you so much.
This is a great day for Mr. Williams, and thank you for having me on.